former President Trump argues that criminal liability for former presidents risks chilling presidential action while in office and opening the floodgates of meritless and harassing prosecution. These risks do not overcome the public interest in fair and accurate judicial proceedings, which is at its height in a criminal setting. So, going by the separation of powers and checks and balances, in a criminal setting, the judicial power of judicial proceedings is at its height, whereas a presidential immunity of a former POTUS who has been indicted for breaking the law is at its lowest. But the chance that we now and then, let me restart. But the chance that now and then there may be found some timid soul who will take counsel of his fears and give way to their repressive power is too remote and shadowy to shape the course of justice. The Supreme Court, reinforced the point in United States v. Nixon, holding that it could not conclude that presidential advisors will be moved to temper the candor of their remarks by the infrequent occasions of disclosure because of the possibility that such conversations will be called for in the context of criminal prosecution. We cannot presume that a president will be unduly cowed by the prospect of post-presidency criminal liability any more than a juror would be influenced by the prospect of post-deliberation criminal liability, or the executive aide would be quieted by the prospect of disclosure of communication in a criminal prosecution. Moreover, past presidents have understood themselves to be subject to impeachment and criminal liability, at least under certain circumstances, so the possibility of chilling executive action is already in effect. When even former President Trump concedes that criminal prosecution of a former president is expressly authorized by the impeachment judgment clause. So that's, when you go to the oral arguments where the court pretty much decimated Sorrow, Donald's attorney, where he could not get out of the impeachment judgment clause, the court got the concession it needed to explain to us that, they themselves are saying that they're not completely immune, and then they're asking for complete immunity. So I love that the court brings it up and the oral argument. It's just poetry. Additionally, recent historical evidence suggests that former presidents, including President Trump, have not believed themselves to be wholly immune from criminal liability for official acts under their presidency. So we talked about President Nixon and offering him a full pardon. Then there's, before leaving office, Bill Clinton agreed to 5-year suspension of his law license and $25,000 fine in exchange for independent counsel Robert Ray's agreement to not file criminal charges against him. I didn't know that. President Trump's 2021 impeachment proceedings for incitement of insurrection, his counsel argued that instead of post-presidency impeachment, the post-presidency impeachment, meaning, by the time the impeachment proceedings were happening, he was already a former president. The appropriate vehicle for investigation, prosecution, and punishment is the Article 3 courts, as we have a judicial process and an investigative process to which no former office holder is immune. So, this is Donald's impeachment haunting him, and his own counsel's arguments haunting him now. It doesn't help him. In light of the express mention of indictment in the impeachment judgment clause and recent historical evidence of former presidents acting on apparent understanding that they are subject to prosecution even in the absence of conviction by the Senate, the risk of criminal liability chilling presidential action appears to be low. Instead of inhibiting the president's lawful discretionary action, the prospect of federal criminal liability might serve as a structural benefit to deter possible abuses of power and criminal behavior. As District Court observed, every president will face difficult decisions. Whether to intentionally commit a federal crime should not be one of them. Former President Trump next urges that a lack of criminal immunity will subject future presidents to politically motivated prosecutions as soon as they leave office. In the civil context, the Supreme Court found official act presidential immunity necessary in part to avoid subjecting the president to trial on virtually every allegation that an action was unlawful or that taken for a forbidden purpose. But the decision to initiate a federal prosecution is committed to the prosecutorial discretion of the executive branch. Prosecutors have ethical obligations not to initiate unfounded prosecutions, and courts presume that they have properly discharged their official duties. There are additional safeguards in place to prevent baseless indictments, including the right to be charged by a grand jury upon finding of probable cause. Grand juries are prohibited from engaging in arbitrary fishing expeditions and initiating investigations out of malice or an intent to harass. Additionally, former President Trump's predictive judgment of a torrent of politically motivated prosecution finds little support in either history or the relatively narrow compass of the issues raised in this particular case. President Trump acknowledges that this is the first time since the founding that a former president has been federally indicted. Weighing these factors, we conclude that the risk that former presidents will be unduly harassed by meritless federal criminal prosecutions appears slight. On the other side of the scale, we must consider the constitutional weight of the interest to be served by allowing the prosecution of a former president to proceed. The public has a fundamental interest in the enforcement of criminal laws. Our historic commitment to the rule of law is nowhere more profoundly manifest than in our view that the twofold aim of criminal justice is that guilt shall not escape or innocence suffer. As the Nixon court explained, wholly immunizing the president from criminal justice process would disturb the primary constitutional duty of the judicial branch to do justice in criminal prosecutions, to such an extent that it would undermine the separation of powers by plainly conflicting the function of the courts under Article 3. This is from U.S. v. Nixon. There's also a profound Article 2 interest in enforcement of federal criminal laws. The president has a constitutionally mandated duty to take care that the laws be faithfully executed. The president is responsible for investigating and prosecuting criminal violations. Beyond simply making explicit that a president must enforce the law, the Take Care Clause plays a central role in signifying the principle that ours is a government of laws, not of men, and that we submit ourselves to rulers only if under rules. It would be a striking paradox if the president, who alone is vested with the constitutional duty to take care that the laws be faithfully executed, were the sole officer capable of defying those laws with impunity. The federal prosecution of a former president fits the case when judicial action is needed to serve the broad public interests in order to vindicate the public interest in an ongoing criminal prosecution. The risks of chilling presidential action or permitting meritless, harassing prosecutions are unlikely, unsupported by history, and too remote and shadowy to shape the course of justice. We therefore conclude that the functional policy considerations rooted in the structure of our government do not immunize former presidents from federal criminal prosecution.